International Virtual Conference on the Future Dispute Resolution in Infrastructure Sector 2021. Before going ahead with the further technical sessions of the conference, I would like to request Professor Dr. Jairul Islam to kindly brief about the proceedings of yesterday's session.
Thank you, Akash and Pooja. Dignitaries, distinguished guests, faculty colleagues, participants, students, ladies and gentlemen. A very good morning and warm welcome to the second day of the International Virtual Conference on the Future of Dispute Resolution in Infrastructure Sector. I, Dr. Zahirul Islam, Faculty Coordinator of this conference, would like to sum up the first day of 2 days conference. On the first day of the conference, inaugural address was delivered by guest of honor, Dr. Lalit Bhasin, Chairman, Chartered Institute of Arbitrators, followed by release of e-book of abstract by Dr. Lalit Bhasin. Keynote address was delivered by guest of honor, Professor Dr. S. Santa Kumar, Director, Gujarat National Law University and Director of Gujarat Maritime Arbitration Center. Special address was delivered by guest of honor, Mr. Tushar Mehta, Solicitor General of India, followed by special address by guest of honor, Tan Sri Datuk Suryadi bin Halim Umar, Director of Asian International Arbitration Center. In technical session 1, which was primarily focused on FDI in infrastructure sector and resolution of investment dispute, we had the opportunity to have address by guest of honor, Mr. Amar Sundaram, India Head Legal Corporate Governance and Regulatory Affairs, Royal Bank of Scotland, NatWest Group, followed by address of special invitees, Dr. Mary Mitchie, lecturer in commercial law, Queen Mary University, London, where she spoke about English and Greek perspective of dispute resolution. And Mr. Deepak Narayan, partner BDN Chambers. We also had a special address by Mr. Samir Shah, Director, Chartered Institute of Arbitrators, India. In technical session 2, which was primarily emphasized on public-private partnership and dispute resolution, we were honored to have with us guest of honor, Mr. Vikram Nankani, Senior Advocate, Bombay High Court. We also had opportunity to hear special address by Mr. Alexander Lidjendorf, Senior Counsel and Arbitrator at Amerala, United Arab Emirates, which was followed by special address by Mr. Avinash Barik, International Case Counsel at Asian International Arbitration Center, Malaysia. In addition, in both technical session 1 and 2, we had 17 paper presenters who presented their research paper. The day 1 of the conference was concluded with the concluding address of Professor Dr. A.V. Thomas, Director, Adani Institute of Infrastructure. This was the overview of the day 1 of the conference. Now I formally welcome you all in the day 2 of the 2 days international conference. Thank you all for being part of this conference and gracing the event. Thank you. Now over to Akash.
Thank you, sir. I would now take this opportunity to begin with technical session 3 of the conference. Today, we have with us Mr. Philip L. Brunner as a guest of honor. To briefly introduce Sir, Philip L. Brunner, Esquire, is one of the world's leading full-time arbitrators, mediators, and resolvers of construction, engineering, and infrastructure claims and disputes arising in the United States and globally. Sir is also director of James Global Engineering and Construction Group. For more than 25 years prior to joining James, Sir was also member of panels of arbitrators of other dispute resolution organizations. Sir has immense experience of more than 40 years and also served as a lead counsel in over 100 arbitrations and litigated cases venue in over 30 states. Sir holds Bachelor of Arts degree in History from Princeton University. We heartily welcome you, sir, and we request you to kindly address the gathering.
This is Philip Brunner. Can you hear me?
Yes.
Yes, sir, we are able to hear you.
Yes, thank you. Well, it is a privilege for me to be invited to speak to this wonderful conference. I wish to begin by addressing the subject of construction industry dispute resolution, which obviously raises a question: why is dispute resolution outside of the courts necessary? We heard, of course, a commentary yesterday from a number of people about the difficulties with the backlog in cases in India, but let me assure you that that is an issue that all over the world. If you allow me briefly, I would like to read a comment by our United States Chief Justice of our Supreme Court, Warren E. Burger, back in 1985. This was advice, compelling advice that he was giving at the time to the American legal profession. And he said this: the obligation of the legal profession is or has long been thought to be to serve as healers of human conflict. To fulfill that traditional obligation means that there should be mechanisms that can produce an acceptable result in the shortest possible time, with the least possible expense, and with a minimum of stress on the participants. That is what justice is all about. He goes on to say, one thing an appellate judge learns very quickly is that a large part of all litigation in the courts is an exercise in futility and frustration. A large proportion of civil disputes in the courts could be disposed of more satisfactorily in some other way. And he went on at that time to talk about arbitration as being a way of doing that. Now, what is it about construction that gives so many issues with regard to litigation, and that warrants dispute resolution procedures outside of the courts? And first of all, we have to recognize that construction is technologically complex. It's something that not a lot of people fully understand unless they have spent a great deal of time in the field. And we have, of course, our design people, engineers and architects, construction people dealing with construction management. We have people involved with materials and material sciences, governing the extraction, formulation, and manufacture of building materials. And on top of that, construction in most cases is unique. That is, every piece of infrastructure, it may have a unique design, but it is certainly going to be built on a unique site, perhaps by a unique aggregation of companies operating without economies of scale in an uncontrolled environment where productivity is affected by weather, by geology, local labor, and site accessibility. In short, construction offers challenges in understanding what's going on that few other industries require. Now, thirdly, as a consequence of construction's technological complexity and its uniqueness, the law governing construction is becoming more complex and is evolving into what courts around the world may regard as a separate breed of animal. Construction law today comprises centuries-old theories fortified by statutory law in our various countries and seasoned by contextual legal innovations reflecting broad factual realities of industry experience, custom, and usage, utilizing specialized language, implied duties, and other concepts of foreseeable risk allocation. And so finally, then, what does this mean in terms of resolving disputes? And it's that because of the technological complexity and the legal complexity and uniqueness of construction generally, the whole issue of legal proof of causation and quantification of damages necessarily relies heavily upon the opinion of experts. And of course, the issue with experts is whether courts are going to be able to fully understand just what is being said. And I offer the sage advice of one of our United States federal judges some years ago in a complex construction case, in which before the trial started, he told the parties this, and he included this language in his opinion later on. He said, being trained in this field of construction, you are in a far better position to adjust your differences than those untrained in its related fields. As an illustration, I, who have no training whatsoever in engineering, have to determine whether or not the emergency generator system proposed to be furnished met the specifications when experts couldn't agree. This is a strange bit of logic, and the object of litigation is to do substantial justice between parties litigant, and the parties litigant should realize that in most situations they are by their particular training better able to accomplish this among themselves. And so what has that meant? It's meant for the last 150 years or more in the construction field, people involved in construction disputes have found their way to attempt to have their disputes resolved by individuals in whom they have confidence, in whom they know has knowledge of the factual underlying of the dispute and who are fair people. And that's been the basis for arbitration. One of the issues with arbitration in the last 20 years, however, has been that the process has appeared to become judicialized. That is, it has combined all of the deficiencies of litigation, such as extensive motion practice, unlimited discovery, unwanted judicial proceedings, liberal hearing due process time, and very heavy expense, and issues regarding confirmation of awards. And so because of this, I'm going to be addressing arbitration in a few minutes as well, but because of all of the difficulties with perceived judicialization of arbitration, the construction industry around the world has really developed 10 different processes for dispute resolution that are private processes that are followed today almost uniformly. With regard to these 10 processes, we've heard some yesterday, such as mediation or negotiation, and I know there's another technical session on negotiation skills. But let me just run through the 10 most widely used construction industry ADR methods available today. And these are range in a continuum from the most informal to the most formal. So starting with the most informal, of course, we have discussions and negotiations on the project at the very lowest level of where the dispute arises. And there are no rules really applicable to these negotiations except ethical conduct, patience, sensitivity, good humor, careful listening, and a reasoned evaluation of risks. Now, not all people on site, however, are able to have all of those qualities, and particularly if there's emotional issues involved too. Perhaps people dislike each other, whatever. And so the industry has recognized the importance of what is called structured negotiations. That is, if disputes are not settled at the project level, they should be bumped up to people at higher levels in the companies of the disputing parties. And it may be vice presidents, it may go up to the presidents, or maybe 2 or 3 structured stages, where at each stage, if they don't settle, then in a prompt period of time, well, then things move up to a higher level. And this has worked well, and structured negotiations are now being written into contracts as a requirement for dispute resolution. And in order to help facilitate the whole dispute resolution process, there is a third process that comes into play from time to time, and that is standing project neutrals. That is, the parties pick a project neutral who will be on call and who can help them decide what specific dispute resolution process is most suitable, and on occasion can ask the person if they feel that the person can contribute, is an early neutral evaluation where the neutral can talk to both parties and simply point out issues that they need to consider in going ahead with their decision-making process. There is a fourth process that is used, and that is called the initial decision maker. If you go back into the history of construction, at least construction contracts, I see this particularly from the point of view of the United States, in our very earliest uniform contracts used around our country, construction contracts that is, there was a provision under which the architect of record exercised a strong hand in resolving disputes. And only if the architect's decision failed to resolve disputes could the parties go on to arbitration. But I think over the last 20 years, it's been recognized generally that the architect has personal interests in the adequacy of its plans and specifications. Of course, it's paid by one party, usually the owner, the employer. And as a result, why there has been less trust in the professional of record to decide initially disputes as they arise. And so at least the American Institute of Architects construction documents now provide or allow the parties to appoint an initial decision maker who will make those key decisions in lieu of the architect of record. The fifth process that is used very widely now on large infrastructure projects is a standing dispute review board. Now, this review board typically is comprised of 3 individuals selected by the parties at the beginning of the project or even after a dispute arises. And the purpose of the board is to listen to the parties and give non-binding decisions. And according to the Dispute Review Board Foundation, a worldwide organization, by some 98% of well over 1,000 projects that have used the DRB process have been completed without resort to arbitration or litigation. Process 7 is mediation. And of course, if parties go through structured negotiations and they still feel that they need a third party to be involved in the dispute resolution process, a mediator can be hired. Now, a mediator, of course, is somebody with special skills in understanding specifically the factual context of the dispute, but also the ability to work with both sides to find a consensus upon which they can settle the matter. Typically, it means that mediators must be more than doing mere shuttle diplomacy. That is, going back and forth between the two parties and simply saying one side offers so much, how much are you willing to take? The whole key to mediation is what I call evaluative mediation, which involves a mediator who can, again, provide a detailed evaluation of the parties as to the risks that they face, the issues that they face, and make sure that both parties have a clear-eyed appreciation for the issues if they don't settle. And typically, good mediators will settle most of the cases that come before them. Process 8 is called adjudication. And this is a process that came out of the United Kingdom's Housing Grants, Construction and Regeneration Act of 1996. And it is today called generally, quote, settle now and argue later, unquote. And what this process involved is the parties' appointment of a standing adjudicator who within, say, 30 days must decide a dispute that comes up while the job is in progress. That is binding through the rest of the project until such time as the project is over, and then the parties can go back and argue if they wish, and take it into court if they wish, if they've reserved their right to do so. But it's worked very well in England and the United Kingdom, and I think it's recognized and used elsewhere. Process number 9 are a process of what are called mini trials or mini arbitrations, where the parties simply call together a few judges or a few arbitrators to hold sort of expedited, non-binding proceedings where then they would give a recommendation to the parties as to the likely outcome. And finally, 10th is, of course, arbitration itself. Now, notwithstanding all the complaints about arbitration, it is by no means consigned to the dustbin of history. Fixes have been and are being proposed, and I think people recognize today that the important things with arbitration is first the drafting of a well-thought-out arbitration agreement that confirms applicable law and rules and arbitration venue and the powers of the arbitrators. And most importantly, provides for selection of arbitrators by the parties with skill and expertise in construction industry practices, construction law, and case management. And that is really critical. It's not just enough to have a group of people off of a list. Typically today, in any large major case, the parties are picking individuals from around the world and agreeing on, say, three arbitrators with each, say, if there's two parties, well, each picks one, and then the two of the arbitrators pick the third. That's what's used on in UNCITRAL arbitrations, for example, but I think that practice is following through in a lot of other ways. So finally, the important thing is to get arbitrators who have expertise in the substantive law of construction in the country involved, and procedural management expertise and procedural management of the cases to make sure that they move along to rapid conclusion. And then finally, who possess the trust and respect of the parties. Now, if for some reason parties wish to have an opportunity to challenge arbitration awards after they're made, there is a process called appellate arbitration. And I mentioned that in India, your Supreme Court, in the case of Centro Trade Minerals and Metals versus Hindustan Copper Ltd, in a decision issued December 15, 2016, has confirmed the right of parties to agree to consensual appellate arbitration. And what that does is, under proper rules, it allows avoiding a large part of the frustration of going into court to challenge an award. And typically, if there is an appellate arbitration award rendered by very few courts, are not going to enforce it. And so there's a lot to be said about it. I wish to emphasize that I have submitted a paper which goes into great detail in all of these issues that I've discussed. And I appreciate the opportunity to speak with you. Thank you very much. Hello. Hello.
Thank you, sir. Thank you so much, sir. Akash?
Thank you so much, sir.
Thank you.
We also have the privilege to welcome Datu Professor Sundra Raju. To introduce sir, he is President of Asian Institute of Alternative Dispute Resolution 2018 till date and Managing Director of Sundra Raju Arbitration Chambers. Sir holds prestigious fellowship from Asian Institute of ADR, Fellow of Malaysian Institute of Arbitrators, Fellow of Indian Council of Arbitration. Sir is founding president of Asian Institute of Alternative Dispute Resolution, Chartered Arbitrator, FIFA Adjudicator Chamber. Sir has also served as president for Chartered Institute of Arbitrators in 2016, then Asian Pacific Regional Arbitration Group. in 2011 and many more prestigious committees. Sir is also founding president, Society of Construction Law, Malaysia, founding president, Malaysian Society of Adjudicators, founding president, Sports Law Association of Malaysia. We humbly request sir to kindly address the present gathering. Thank you, sir.
Thank you. Can you hear me?
Yes.
Yes, very good. Excellent. First and foremost, I would like to thank the organizer, Adani Institute of Infrastructure, for inviting me to speak in this event. Special acknowledgement to the conference chairperson, Professor Dr. Lakshmi, and also the dedicated organizing team for the brilliant coordination and wonderful event. I will actually talk about the construction industry dispute resolution, how I see it in India. Starting off, construction disputes are primarily technical in nature. They arise during the execution of the project. They occur after the project is completed. More often than not, when it's not resolved quickly and efficiently, it has a cascading effect. The cascading effect leads to inefficiencies, it leads to cost overruns, it leads to problems of cash flow for both the employer and also the contractor. Now, basically at the end of it, this kind of disputes have the far-reaching impact of cost, delayed completion, and I think really is opportunity cost. That means you could have done something else. So, the current state of construction industry in India is very, very interesting, that the Indian government has been very proactive, and it has actually come out with what is called the National Infrastructure Plan, and I've been looking at it. And also it has announced this affordable rental housing complex. Then they have also pushed the industrial segment, towards what is called Atman Bharat. And basically, the forecast for 2021, it actually opens up investment opportunities, for people who are interested in the construction industry. Although everybody is saying this is not an industry to go to because there's so much problem. I think the problems really we understand from is coming out from the pandemic-driven COVID-19 difficulties. It has hit everybody around the world. In Malaysia, in Southeast Asia, I think the only country that seems to be doing okay is China, but all the rest of the world is actually having difficulties. It has depressed economic activity. And I think, looking at the figures in the second quarter of 2020, there has been an unprecedented 50.3% contraction in the construction industry. So I think Indian global business, they actually predict what goes down must come up, not what goes up must come down, but what goes down must come up. And then everybody is actually very optimistic that 2021, with the vaccine, with all the management of the COVID pandemic, there will be at least 11 to 12% growth in 2021 in the construction industry. So the loss fallback, the ground will be actually regained. Now, this will actually tie in with the overall pattern of Indian economic growth in 2021. In 2025, the prediction is that the construction market in India will be the third largest globally. So we are talking of size. The size is amazing. Third largest globally. So we have to actually see where it's going to be. I think that the action is going to be in Asia. I think that's quite clear. I'm quite sure that Southeast Asia will be there. China will continue to do what it does, but India will play a prominent role. In fact, I see my own reading, I mean, the old world is there. It will continue to be there. But the real reading in Asia will be the three places that you have to look at. First, you have to look at India, you have to look at China, you have to look at Indonesia. So, I mean, and all have massive young population, and then I think the growth will come from there. Now, construction will continue to be disrupted while there's a labor shortage. It's strange, you know, we have in India a tremendous labor pool, but you know, they can't get to the site and work. I think once that is done, that is going to actually solve the problem. But now at the present moment, what is the problem? The problem is a liquidity crisis, rising project costs and dwindling amounts, and then disputes are inevitable. You can postpone them, but you have to actually deal with them. And when you cannot perform the obligations in a contract, whether you call it force majeure or something or whatever it is actually a problem. It is a problem that has a multiplier effect on the entire project. One effect, one cause has so much repercussions that now we have to talk, as the earlier speaker spoke about, is that we have to talk about dispute resolution forums. You know, how are we going to deal with this? I think going back again, you know, there is no fixed formula for the selection of the forum. How do we want to solve it? We have to look at the underlying agreements that the parties have, or the I think sometimes even the central government or the state governments have. And then if they do not have that kind of agreements, they will have to enter into some kind of agreement to resolve their disputes, or straight away go to litigation. Litigation is always there. The courts are always there. But of course, the best resort where technical disputes are concerned is to move into alternative dispute resolution. And when we talk about alternative dispute resolution, as Mr. Philip Brunner has actually explained, it is a range. It is a range of disputes, but it is alternative to the courts. It's alternative to litigation. But let's go back to the courts. You know, when you go to the courts, what is going to happen? You are actually in a process of resolving a dispute. You want to actually look and establish liability, and then you have to also be very careful that this, normally there are two parties, but let's say a construction contract from standpoint of what is simple to liability can mushroom into many other parties being brought in as third parties and other things, which I think, of course, arbitration is trying to mimic by multi-party arbitrations and all these things, but there are some limitations, but the court's limitation is less. There seems to be an ability to actually expand the dispute if he really wants to, and parties can bring in other parties. So, but the real problem is this: when you go to the court, you are actually getting a judge, and a judge, as we know how they are trained. I mean, as lawyers, I mean, we essentially there are very few judges who are actually architects. If you don't have a law degree or engineer. So there is a great reliance on expert evidence, and there's formalities and other things that go on. But I think the more important thing is that actually is a problem also for cross-border projects where enforcement is concerned, because you can't enforce an Indian judgment overseas unless you have a reciprocal arrangement for enforcement of judgments, and I believe it is limited in most countries. My country is very limited. It's been actually dwindling and being restricted. So the best way is to actually go to ADR, that is alternate dispute resolution. Now it is actually very clear. We are talking about 3 steps now. One, when we talk about ADR, people are really talking. You know, I can see in China with the setting up of IPACSO, which is their new international body, they are emphasizing on prevention. They say prevention. Prevention means we don't want a dispute. There shouldn't be a dispute at all. We will do this at front end meaning that we will actually look at the contracts, we will look at the procedures, we will look at the arrangements, we will look at the ways of people tying up contracts, but to prevent disputes from coming. And then when disputes do come, they are looking at the way they want to deal with it. And most probably they want to use soft methods. They don't want to use right-based methods. They want to use interest methods like Mr. Philip has pointed out, mediation, negotiation, other types of methods that are interest-based, which actually get an amicable settlement some way or another. Whereas the approach on dispute resolution by rights, it becomes limited. But at the end of it, you cannot resolve your dispute. You still have to go to arbitration. And when you go to arbitration, it's very, very interesting. Arbitration is very efficient if it's run well. If you have the right people, you must have also the right seat. You have to, and when you talk about the right seat, you have to look at the London principles, the 10 principles of having all these items there. And then you see that most of us will seem to have those items in our countries, but they will fall short maybe in implementation or the manner it's done. Sometimes the legal profession is not open. Sometimes the judiciary is not so strong. Sometimes the infrastructure is poor. And then maybe the legislative framework is not working. But in India, it is very, very interesting. Since 1996, when the Act changed to the model law, there was actually, in fact, India was one of the earlier countries that went on to the model law in 1996. When the English came out with the Arbitration Act, they changed it. But I think the Indian approach now, after the Sri Krishna High Level Committee recommendations in 2015 and 2019, in fact, in 2020, there is even a decree coming out, and there's a latest presidential decree that is being in the form of ordinance coming through. Now, what does this show? The government of India, that's through the legislature, is very committed in making India a safe seat for arbitration. And the courts have been playing a part, because I'm writing a book on Indian arbitration, which will come out in June or July. I've taken a chance with a young team. I'm writing this book, which is already about 1,500 pages now. And we explore the whole thing. And what amazed me is the change that has come about. Now, when you look at the Act, there is very few acts in the world that actually set a time frame for you to finish an arbitration, particularly domestic arbitration. I think the things normally drive. You want to become an international seat, your domestic arbitrations in a country as the size of India must have strong institutional arbitrations with domestic arbitration driving it, and then the international arbitrations will come in. If you are a country like Singapore, which is very small, it can only look for export market. So it's very interesting that the most number of parties in Singapore SIAC are Indian parties. So that really shows, the market that you have. So we would talk, even if you look at ICC and all the other places. But I think the amendments, the 1996, but the real amendments in 2015, 2019, 2020 have made a difference. Now, I think the other one that I'm running out of time, the pandemic has caused other problems. We need to look at mediation. I think Mr. Philip has explained that very well. But the most important thing is that we have now a powerful convention on mediation called the Singapore Convention, which is the UN Convention for the International Settlement Agreements arising from mediation. India is one of the first signatories. India has to ratify the convention. Now, India also has to look, because to ratify the convention, you are required to work within their own domestic processes and procedures to bring them in conformity with the protocols. Now, mediation is actually recognized in the Arbitration Act as conciliation because it's not separated. So I think this is where the brains have to go in now. The powerful brains of India, the legislative brains, have to actually discuss how to actually take advantage of this procedure, international convention, which you are already a member, you will rectify it, but what is the thing that you're going to set up statutorily? What is the training you're going to give? What is the group of people you're going to have? And that will actually bring a key change to dispute resolution in the construction industry, particularly. Because I think if you look at every arbitration procedure in the world, it is normally the construction industry that actually dominates maybe 60% of the arbitrations in the country. I can talk about court annex and all this thing. I'm running out of time. The other thing is India is doing something that a lot of people, which is under the radar. There is actually a response to the China's Belt and Road Initiative. India is doing a lot of connectivity projects in its neighborhood. It is not only doing connectivity projects in its own country, it's doing projects in Afghanistan, it's doing projects in Bangladesh, it's doing projects in Sri Lanka, all in the neighborhood. And what does this all bring? It will bring disputes, or you need to be more efficient so that you can deliver the products. So I think this is something, again, I've been sitting on Indian parties involved in arbitration in Africa. Indian parties are quite big in Africa. They are still very big in Africa. It's either an Indian party or a Chinese party. I've hardly seen anybody else involved in disputes with the local governments or local authorities. So because they are doing so many projects. And then I think the last thing, we have to embrace technology. India, like what we are doing now, our conferences from henceforth will all be like this. It will be virtual. So our hearing cannot be in person anymore. Even if we get vaccinated and all these things, there is a great likelihood that people will actually may choose between virtual hearings and not in-person hearings. And I think that saves actually a lot of time, provided the platforms are created. So I think this where is the arbitral institutions, the government bodies, the universities, the various people have to do, and there are so many protocols and all these things. So I have to end this talk now because it's 1:08. And I have to say is that we now look at two things. We look at the law, in fact, three things: law, we look at technology, and then more importantly, we look at people. When we put these three things together, that's what will be a successful dispute resolution mechanism for the construction industry. And that applies across the board, not only to India. Thank you so much. I've taken a bit more time. Sorry about that.
Thank you so much, sir. We look forward to hear more from you. Floor is open for the audience to post the questions.
Yeah, questions. I just have to show the conversation.
Yes, sir. We have one question from Jinil Patel. Can we say that doing arbitration while having international deals is more preferable rather than court?
Can I have the question again? Sorry, I didn't understand.
Yes, sir. Sure, sir. Can we say that doing arbitration while having international deals is more preferable rather than court?
I think the main thing about international disputes, of course, I think the main thing it has to actually arbitration will be preferable simply because of the New York Convention. The New York Convention is actually creates what is called a universal enforcement. Sorry, can you see me? I find the chair be different, but if I answer in short, if it is international disputes, involving international parties, one Indian party, one let's say a foreign party or two foreign parties itself, it has to be arbitration, because the places that you are going to enforce will be not in the country it has to be enforced through different jurisdictions. There's 166 countries who are members of the New York Convention, and I think it is only natural that if you are going to be an international trading nation, that you have to be you have to choose arbitration. That is why I think training is very important. I think the Indians do not have a large cadre of international arbitrators, and this is, I think, one. But I think the number of people who have international young people, I've been working with a group of young people, very talented, very clever, very knowledgeable, is there. So I think, you know, that will take a little bit of time. So it's time for the new generation to come up, and this is only through training. And this is why we set up Asian Institute of Alternative Dispute Resolution, to actually give an opportunity for accreditation and membership through that. Thank you. That's the next question, is it? What reforms would you suggest in the existing framework?
Yes, sir.
You know, okay, you know, I mean, I can't come and tell the Indians what to do, but, you know, I can generally say, you know, that one is that you have the human resources. You must develop the human resources in terms of specialized training. You must actually allow them into the system. You cannot actually, in fact, I think, you know, one of the real difficulty, even like for me, coming from a smaller country, is the barrier to go international. It's very, very difficult to go international. And then even in your own country, you will find that to reach that level of prominence, you will have difficulties also. So it has to be made easier by actually a plan. There must be a plan. I think Singapore is the best example. It decided long ago it's going to create 50 top arbitrators of the world. They have done that. I think they have at least about 50 now, who can go anywhere in the world, sit in any tribunal. That is a plan. But you know, the way it is done is that there must be commitment. There must be actually direction, and you cannot. You know, one of the things that I state in my book, you know, when I did the legislative reform, in fact, I have this chapter here, which I was looking at what I was saying. I said Indian reforms is like taking a step forward and, you know, taking one step forward and 2 steps back, and then taking 3 steps forward and 2 steps back. So it's quite interesting to see. I mean, it is not a criticism. In fact, I try to justify why I think it's like that. But generally, I think after 2015 to 2019, it has been amazing, the commitment. Okay, and that's it. Huh? Anything else? What is the core difference between mediation and arbitration? Is that the question? I can't see all, you know, but yeah, I'm trying to. Okay.
Yeah.
The core difference, I think Mr. Philip has explained that. First thing is that it is the attitude towards the dispute. One is called rights-based, the other one is called interest-based. Rights-based, as we know it in law, is that you apportion blame. That means who is right, who is wrong, who is in breach, who is not in breach, is it lawful or unlawful? In the case of mediation, that is not the issue. What is the best interest for the parties if they settle it? How can we solve? We don't talk about rights. We may talk about rights to see where we stand, but after that, how can we solve this problem for the best interest of all the parties? You don't have to spend 5 years in court and then getting a judgment nobody is happy with. Or can there be a innovative judgment, for example, innovative settlement? For example, okay, you are losing money on this project, that's why you're making a claim against me. You don't worry, I will not pay you this claim, but nevertheless, I'll give you another project where you can recoup, but you price it properly. But this one, we have to close the thing. So, you know, it can be innovative like that. So I think that's the main difference. The neutrals, they have to be highly trained. In fact, the skill sets for a mediator is very different from an arbitrator. An arbitrator is a judge, essentially. He has to shift through the evidence. He has to actually look at the facts as it comes out, and then the law has to be applied. And then hey presto, you get an answer, and then we always have this jurisprudential argument in our mind. What is the right answer and whether there's one right answer. And for me, I believe there's only one right answer, the answer that you give. And that's why you have to do it well. You have to follow due process. You have to treat parties equally, and then you have to hear out the parties. You have to follow the procedure, that's mandatory procedures that are laid out in the law. And then you must write an enforceable award. In the mediation, it's a bit different. You can talk to the parties. In arbitration, you can't go and talk separately or unilaterally to parties. In a mediation, you can talk to parties, you can caucus with them. More importantly, you then persuade them. In an arbitration, you're not allowed to do that. But there is now hybrid procedures coming in. The system is changing, that we have now quite common arbitration, mediation is coming in, and then arbitration again. They call it up-met arbitration. There is also what is called met-up. So there are combinations, hybrid. People are becoming innovative. Then there are other ways also doing it. So rights-based, as Mr. Philip has pointed out, there is actually what is called, for example, adjudication. Adjudication, again, is a rights-based thing, temporary enforceability. It is something that perhaps India may want to look at for its construction industry, just to maintain cash flow. A cheap method. Normally, there is no oral hearings. Even oral hearings are very, very limited. Yeah. So I think that's the answer. Anything else?
Yes, sir. So may I read the next question with your permissions?
Sorry, say that again.
May I read the next question with your permissions?
Yes, please. Yes, please.
So it's by Mr. Jatan Rodriguez. The possibility of mediation is an interesting possibility for construction disputes. However, I'm curious about your opinions on the usefulness of mediation in construction disputes with state parties. And then sir, it is continued again. Then in India, the largest construction contracts are always with the state, and the state as a party is naturally limited in being flexible about options and solutions. Mr. Jatan personally thinks that he understands on the subject is that state officials often prefer a binding decision as to voluntary paying out a sum to a contractor, because this may raise the perception of vigilance issues, corruption allegation. Similarly, future contracts cannot be assured as options due to the L1 tendering method that must be followed for all public projects. And he wished to listen on this.
No, I agree. I agree. Sorry. I agree simply because I've done a number of public sector undertaking arbitrations where public sector undertakings are actually being sued, or they are not suing, they are being sued. And it came across to me that the matter could have been settled in some benefit, but no, everybody wanted a binding, especially the officials, quite rightly put, wanted a binding award. Once the award, I don't know whether it's because I never follow. Once I finish my arbitration, I never follow the thing. We just do the award and we move on. I think there is actually a perception that it will not be effective if you have that kind of attitude. I suppose then it is for the government to actually work out, or these public undertakings to work out a structure where they can actually accept a settlement. I suggest maybe what they should do is an independent assessment of the dispute itself and get a report on what should be the outcome if they actually go to dispute resolution, and this will be the outcome. Of course, you cannot be 100% sure, but if the facts are clear and if the law is clear, then the answer should be that answer, and or within a range. So with that range, perhaps then people can be empowered to discuss and settle the thing. But I understand the issue of perception. I understand the issue of corruption. I understand the issue of the difficulties of accountability. So maybe in that situation, mediation has to, there has to be some kind of task force set up to analyze the problem and come up with solutions. There are always solutions. It may be flawed, it may be not complete, there may be some difficulties, but I think it can be attempted. Why not for smaller things? Why for the bigger? But the bigger contracts is the one that makes more sense, because it's normally when you go to a, let's say, international forum, the fees are quite high, 3 arbitrators, international, and then the judicial, the time that is taken, by the arbitral panel, while it can be very quick, it is also, it takes time. But then after that, the enforcement, if you're not happy with the decision, then you will go through this entire cycle of enforcing. And I don't know how many public undertakers actually pay once they get an award. Do they actually drag it out in the courts and hope for a court order? We don't know. I don't have the statistics in India. How does it work? Thank you. I hope I've answered your question.
Yes, sir. Thank you so much, sir, for such insightful information shared. Thank you so much.
Thank you so much. Thank you for having me. I really appreciate your invitation. And goodbye. I think that's it. Bye-bye.
Good morning. I myself, Pooja Samdani, now take this opportunity to welcome our guest of honor and session chair for technical session 3, Mr. Ratan K. Singh. To introduce sir, he is an international arbitration practitioner and advocate as well as mediator based in New Delhi. With about 25 years of experience, he practiced in India as well as internationally with specialties in construction, engineering, infrastructure, mining, joint venture, franchisee, sales of goods and general commercial and civil disputes. Sir has been awarded with various prestigious fellowship with International Arbitration Institution. So now we request you to kindly take over and address the gathering.
I thank the organizers, Adani Institute for Infrastructure. I must make a mention of Dr. Lakshmi for organizing this event and having me here. When Dr. Lakshmi approached me as founder and chairman of Society of Construction of India branch to support this particular event, I was very glad to know that this prestigious institution has taken this initiative to have such an event. And as a CL, we always support such events. And I'm really glad to have two of my old friends, Mr. Philip Bruna and Datuk Sundara Raju, as my co-panelists. And now I'll start my talk from where my co-panelists left. So issue would be, in construction disputes, what is that parties expect? Parties, as has been said by Mr. Bruna and Datuk Raju, that in construction projects, the disputes are inevitable. Now the question is, what is that parties expect? What is that parties expect? Parties expect a just and fair decision that is commercially sound. And they also expect predictable and consistent outcomes of the decision. Now, the issue to be understood by all of us is it really the case in India and globally? I'll be referring to some of the researches on this particular aspect. And first of all, I'll start with the 2009 research. Actually, today's talk is on quality of decision making in construction industry, for construction industry. So first research and survey I am referring to is 2009 research, which interestingly presented a hypothetical delay dispute on uncontested facts to a number of US construction professionals. There were around 429 responses to the survey. And very interesting finding came out of this survey, and that was that all the professionals to whom this survey was sent and who responded, all of them came out with inconsistent awards, including different apportionment of liability and quantification of damages, despite the uncontested facts. So in a situation where you are having uncontested facts, still all of them give inconsistent award. And it's not only, and the liability, the apportionment of liability was also inconsistent. And so was the case with quantification of damages. The next survey I will be referring to is 2000 survey. This survey involved presenting a multi-claim construction dispute scenario to 5 top English arbitrators and construction arbitrators. Each arbitrator returned different findings of fact and law, including different determinations of liability and quantification of damages. So that is another survey which tells us that same set of facts gives you different awards. Now, next survey I'll be referring to is survey conducted by AAA, that is American Arbitration Association. This is 1994 survey. And in this survey, construction arbitrators were asked whether they follow the law while making an award. Very interesting aspect. And I'll deal with this in a minute. What is the relevance of this question? So 20% answered that they do not follow the law while producing the award, writing the award. They do not follow the law. 72% answered in affirmative. They said they follow the law. Another finding which came out in this survey was 25% of the arbitrators who responded, they said they do not apply the contract strictly. And 67% said that they apply the construction contracts, the contract in question, strictly. Now, before I refer to this slide, this is a 2013 survey conducted by IIT Delhi. In fact, it was conducted under Professor K.C. Iyer, who is one of the vice chairman of Society of Construction or India branch. Before I deal with this particular slide, I must say that what is the relevance of the previous surveys which I have referred to? Question is, what are the expectations of the parties? I would suggest that expectations of the parties who are concerned with the construction dispute is that their expectations are rather grounded in their business relationship. They are looking at commercial decision. They are looking at arbitral justice and not court justice. They want arbitrators. Why for construction industry, arbitration is the preferred mode, and even one of the latest surveys tells us that there is increasing number of construction disputes which are going to arbitration. Expectations of the parties is that we will have arbitrators who understand the industry, who will render an award on the basis of commercial reasoning. They'll be deciding the disputes on the basis of their sense of fairness, equity, and justice. For them, what is just is irrelevant. For them, business decisions which are based on their expectations gives them justice. This is what they look at. Now, whether we have arbitrators, particularly in India, who are trained construction arbitrators, do we engage trained construction lawyers to represent the parties? Answer is invariably no. We do not have good pool of trained construction arbitrators. When I say this, what is that I want to convey? What I want to convey is that the way this whole construction arbitration has evolved globally and in India, and particularly after the model law, which was adopted by India and as well as by other trading nations. Now you have Article 28 of Ancestral Model Law, which has been followed by India in Section 28. Section 28 of Arbitration and Conciliation Act says that arbitrators shall decide the disputes on the basis of the substantive law, and they'll also decide the disputes keeping in mind the contract between the parties. Now there are two schools of thought on this globally. One is whether they should strictly go by the substantive law and they should strictly apply the contract between the parties. And what happens if arbitrator has not done this? Now, to the first question, answer is it is a divided house. I have shown the surveys where some do not follow the law strictly, some follow, some do not follow the contract strictly, others follow. So it is a case situation of divided house. Now question therefore would be, what is the consequence ultimately when awards are taken for setting aside, when awards are challenged, whether awards can be set aside on the ground of erroneous findings of fact and law. Globally, law has been that courts, while deciding the annulment proceeding or the setting aside proceeding, are not supposed to set aside the award on the basis of erroneous finding of fact and law. This is the case in India as well. Even the latest judgment of Sengyong, which you will find in one of the slides in today's presentation, says that erroneous application of law will not be a ground for setting aside of award. But the question is, are we saying that arbitrators are not supposed to apply the law because we have judgments which say that even if there is erroneous finding of law, award will not be set aside. It is a tricky situation, tricky question to answer. The moment Section 28 says that the arbitrators are supposed to apply the law and go by the contract, you will have judges who will simply not agree with the award when they see that substantive law is not followed. Substantive law means law of contract, sale of goods act, transfer of property acts, whatever. So they may say, you have not followed the law, therefore I am going to set aside the award. And even if they do not expressly say so, they can find out ways to set aside the award. Same is the situation when contract is not followed. In 2015, Arbitration and Conciliation Act Section 28 was amended. Earlier, arbitrators were obliged and mandated to apply the contract. Now, there has been given some leeway to the arbitrators when it comes to applying the contract. If we take these two aspects in mind, one, that even if there is erroneous finding on law, award will not be set aside, one, and two, even if arbitrator has not applied the contract correctly, award will not be set aside. Then another aspect comes, and that is, are we suggesting that arbitrators can act as amiable compositor? This is one of the provisions in your Section 28 of Arbitration and Conciliation Act as well, which is again taken from ancestral model law. In fact, ancestral model law had borrowed it from International Court of Charter on Charter of International Court of Justice. Now, if you see Section 28, it says that arbitrator will not act as amiable compositor and will not act ad equo ex bono unless so agreed expressly by the parties. So, is it not a dichotomy in some sense? Or are we saying that the judicial pronouncements in India and elsewhere is giving the leeway to the arbitrators to an extent where they can act as amiable compositor? Ladies and gentlemen, what I would suggest is that, yes, before I give my suggestion and my position, in fact, in 1894, right on building contract, he said, no one can be a better arbitrator than architect, engineer, and contractors. But then you have Section 28 and Article 28 in Ancestral Model Law, Section 28 in Indian Arbitration Act, and similar provisions in other jurisdictions, which says that arbitrator will go by substantive law and they will follow the contract. Now, you have parties' expectations where parties want arbitrators who understand the industry, who understand their expectations, who understand the typical disputes, who understands how those disputes are decided. Yes, technical arbitrators are well equipped to do this, but you have Section 28 coming in the way and various pronouncements, despite of this declaration of law and reiteration of law by Seng-Yong and some other judgments, that erroneous finding will not lead to setting aside of award, finding of law will not set aside of award. I would suggest that best way to deal with this situation is to have somebody as arbitrator who understands the industry, and one who understands the law as well. This combination, professional having this combination, are globally very sought after. I have done many big construction arbitrations where I had the chairman who was engineer turned Queen's Counsel. 2014, I did one arbitration with regard to against a Finnish company where issue was defects in a particular plant. Now, arbitrator was mechanical engineer turned Queen's Counsel. So he was very well equipped to deal with both sides of the dispute. One, the technical side of the dispute, and another was the legal side of the dispute. So the challenge, and same goes with the lawyers. Difficulty today in India is we do not teach laws, construction laws and construction arbitration in law colleges and engineering colleges. We do not have legislations to deal with such aspects. Now, in such a situation, what is the answer? Answer is to have and prepare good pool of construction arbitrators, good pool of construction lawyers who understand industry as well as law. And that is why events like this is very important. SCL promotes such events. SCL organizes such events where we have people from all across the globe who are concerned with construction arbitration. In fact, I have written a book. I have written for a book on construction arbitration, which should be out by March 2021. Now, we need more research on this. We need more literature on this. Now, let us go to the next slide. That is very interesting slide. That is 2013 research conducted by IIT Delhi. This research reveals that both intrinsic and extrinsic factors influence the inconsistent outcome of construction arbitral decision making. And extrinsic factors, intrinsic are facts, correspondences, contractual terms, and applicable laws. But interesting is extrinsic factors: age, background, legal or technical, experiences, employer, contractor bias. So you have people who have employer bias, contractor bias arising out of repeat appointments. Personality traits including morality, untrustworthiness, and so on and so forth. We need more and more research on this. In fact, whenever we have big construction arbitrations and we have appointments of arbitrators, it is very common for the parties to do in-depth due diligence about the potential arbitrators. And that is one of the reasons this research tells us that it does matter. How does construction arbitration in India works? Is that invariably, almost in more than 90% cases, disputes are decided on the basis of correspondences, that is volume of correspondences, I would say. And invariably, the arbitrators and counsels would just not get into the most important aspects, particularly for delay claims. They will not at all go into the aspect of critical delay, overlapping delay, or concurrent delay, or float, and so on and so forth. We all know that all delays do not entitle the contractor for extension of time or for compensation. Only critical delays entitle a contractor for extension of time or for consequential entitlements. Now, what happens? Even when contractors are asking for extension of time, they do not do delay analysis. They do not do delay analysis contemporaneously. They do not have in-house capabilities invariably of having trained programmers, schedulers, and project managers who can really do delay analysis. For EOT or for delay analysis, there are internationally recognized methods. In fact, Society of Construction Law, UK has already is having its second edition of 2017 edition of SCL Delay and Disruption Protocol, which prescribes 6 methods of delay analysis. But difficulty is, in one of my ongoing arbitration, it is a $1 billion power plant construction arbitration. And I'm cross-examining one expert on delay and disruption. And I have cross-examined him for almost 12 days so far. And why? Because the expert did not apply the correct methodology for arriving at the delay analysis. Now, that is in itself a separate subject. We can deal with this as and when occasion arises. But bottom line is, there has to be proper delay analysis. It does not happen in Indian scenario. You do not have a single judgment of Indian courts which really goes into these aspects of critical delays or concurrent delays. This is what we are facing with. There is a lot of unawareness amongst the stakeholders about delay, disruption, quantum experts, their role. It is common globally to have delay, disruption, and quantum experts for construction disputes. But in India, there is lack of awareness amongst the parties, lack of awareness among the lawyers as well as the arbitrators. In fact, in one arbitration, I had to argue whole day just to convince the arbitration tribunal that I should be allowed to cite a foreign expert on delay. Now, these are some of my reflections, and I will not go into how judges decide, how technical people decide. I would only say that judges go into legal nuances. For the retired judges, I mean, the retired judges and the lawyers who sit as arbitrators, they would be inclined to go into niceties of law, legal principles. They do not have neck to go into technical aspects. Also for the regions that they are not technically trained and qualified as engineer or architect. Now, as I said, we need a better pool of construction arbitrator and construction lawyer. I was hearing my co-panelist Datuk Raju when he said that Singapore had decided to have 50 world-class arbitrators, which they have achieved. We as Society of Construction Law India branch, we are also working in this direction, and we are also working to have a better and bigger pool of construction lawyers and construction arbitrators. Delay analysis, I have already referred to SCL protocol, delay disruption protocol 2017 edition. I have my slide contains the web link. You can download this paper, which is freely available. I do not intend to go into the details of all these methods. And the Sangyong judgment I referred earlier, you will find here Sangyong, that is 2019 judgment of Supreme Court. So what are the way forward? Engineering and law colleges should teach construction law and construction arbitration. I get these days I have already got lot of invitations, and in 3-4 institutions I'm visiting faculty for construction arbitration. So there is increasing demand for this. Use of experts, delay, disruption, quantum and experts needs to be improved. It should be, we should think about this. Continuing legal education for practicing lawyers and arbitrators, which is very, very important, for which again, coordinated efforts by all stakeholders is very, very important. As I said earlier, promoting research and literature on the subject is again important, and promoting better record keeping practices by parties in-house. So these are some of the way forward. With this, I must thank once again the organizers for organizing this event and having me here. Thank you very much.
Thank you so much, sir. Sir, we have a question from audience. May I proceed further?
Yeah.
So, sir, there is a question from Dineshwar. It is on, please reflect on proposed amendments 2021 to Arbitration and Conciliation Act 1996 regarding unqualified stay on awards induced by fraud and corruption.
There is a history behind this proposed amendment. So I would refrain from saying too much about this. What I can say is that apparently this proposed amendment says that if an award is obtained by fraud and it is discovered later, obviously awards should be set aside. Obviously, there are even in the parliament, questions were raised as to why fraud and corruption is not defined in the proposed bill. It stops when it says corruption and fraud and corruption. Yes, fraud is already defined under section 34, but for this amendment, what legislature means by fraud and corruption is not defined. So we are, this is still being debated. So let us see how it goes. Yeah, next, if you have any other question.
No, sir. Thank you so much, sir. We look forward to gain more insights from you. Thank you, sir.
Thank you very much. Thank you very much. Thank you very much.
So now we take this opportunity to invite participants for their paper presentation for the technical session 3. The first participant is Ms. Advocate Meera Kumari Singh with us. We welcome you, ma'am. Kindly note that in common you have in total 7 minutes plus 2 minutes of question and answer. One question from audience and the other question from the session chair. Thank you, ma'am. Please, you may take over. Meera, ma'am, are you there? Ma'am, we will take you at the end, like we will take your PPT at the end. Now I welcome Mr. Anil Changorat, sir. We welcome you, sir. Please, you may take over.
Yes, can you hear me?
Yes, sir.
All right. Thank you very much for allowing me to speak. My talk is going to be, it's titled Collaborative Contracting and Appropriate Dispute Resolution in the Post-COVID-19 Era. Now, my paper that I've submitted has got 3 parts, 3 critical parts, but I'd like to, as an overview, highlight some of the key points that were made by our keynote speakers right up till this morning, including Dr. Sundaraju, that kind of explains how my presentation or my points on collaborative contracting and appropriate dispute resolution are relevant. Right, and then I will speak briefly on 3 parts from my paper. First is what the COVID-19 has brought about. 2 is what I call appropriate dispute resolution, not alternate dispute resolution, which both my dear friends Philip Brunner and Dr. Sundaraju has spoken about extensively, so I will only just skim over. And the last part is about collaborative contracting. Now, to start off, I'd like to say a few things about what the speakers from yesterday and today had spoken about and how that is effective. First, Dr. Lalit Bishan said, that the doors of justice is to some extent shut with litigation not being effective and arbitration being too expensive a remedy, often with court intervention, and that effective alternative remedies such as mediation with trained mediators are essential, and dispute avoidance through negotiation is a key point. Next, Professor Dr. Shanta Kumar said that infrastructure is more than just physical projects, as it affects the social economic framework and resources. And there are significant risks and complex issues that arise from construction industry and infrastructure work, with huge cost overruns, serious issues with arbitration of enforcement. And so it is important that steps need to be taken at a time when contracting to incorporate dispute avoidance into the mechanism, considering innovative methods and meaningful ways of dispute resolution. Third, your SG of India, Sri Tushan Mehta, said that disputes increased with multiple stakeholders in infrastructure projects. Issues are specialized and often on factual evidence, and litigants often inflate the claims. And it is important that domain experts need to be involved in the process, that they remain impartial. And the future of dispute resolution includes the use of technology and innovative mechanisms. Fourth was the Dato Tan Sri Omar from the AIAC. He said that with construction disputes, a hands-on approach to handle the complexity of infrastructure issues are important. A strong dispute resolution mechanism is needed, and tangible and innovative arrangements of how you deal with construction contracts. In fact, for example, the AIAC has got the standard form contracts. Those are also critical. Philip Brenner, my dear friend from this morning, said that construction is technically very complex. It offers challenges few other industries face, and construction law is hence therefore complex and very specialized. And you need expert knowledge and opinion, and hence it is very critical that the dispute resolution process is not judicialized, and you take a look at both informal and formal dispute resolution mechanisms for the construction industry. And lastly, Dato Sundar Raju, also a dear friend of mine, he said, there are cascading effects of the problems that the construction disputes can raise, issues of performing the obligations in the contract, considering the underlying contract itself, problems of having the disputes dealt with by third parties, for example, judges that may not be experienced in the field is important. And, in India, the connectivity of projects in the region with the regional country makes it very, very important that you have a mechanism that is really workable. And you need to develop the human resource, knowledge, experience of the construction contracts. And then you have to look at settlement both from the rights as opposed to interest-based settlement. Now, so these are the framework about what I'm going to be speaking about. And I move to my first of the three parts. The first part is what COVID-19 has brought about, right? Shortly into the COVID-19 pandemic, the Minister of Law for Singapore, K. Shanmugam, Senior Counsel, in a CNBC interview on the 7th of April said this, that you are looking at economic devastation, business destroyed, people's lives ruined, and in such situation, you don't talk contract, you talk about equity, you talk about justice, you talk about what is the right thing to do. And that leads me to this part about appropriate dispute resolution and collaborative contracting. Now, while current contracting methods allocate specific responsibilities and risks to parties within the contract, you really have to rethink this process and how best you can deal with risk allocation and whether or not risk should be allocated to one party as opposed to the other, or it should be shared among the parties, because the pandemic has brought about the world change in so much so that everybody is facing the same problem. So why should we have contractors being imposed a lot heavier as opposed to the employers or the developers, right? And so if you take that concept of what the COVID-19 has brought about, and before I go into the part about collaborative contract, let's look at appropriate dispute resolution. Now, why do I say appropriate dispute resolution? Because We've changed. It is not alternate to court and arbitration, but what is more important, what is more appropriate under the circumstances. And both Philip and Dr. Sundaraju alluded to this. You're looking at rights as opposed to interests, and you look at informal as opposed to formal. The way I look at it is there are two main parts of dispute resolution. One is the consensual ADR, and the other is the adjudicative ADR. With consensual ADR,
So we have a last minute left, sir.
Sorry?
We have last minute left, sir.
Yeah, okay. So we have consensual, which parties make a decision, and adjudicative, which third parties make a decision about. And we have all spoken about that. But let's then go into my last point about collaborative contracting. The idea about collaborative contracting essentially is to tell people that, we no longer want to look at the old-fashioned way of dispute resolution where the risks are allocated to one party as opposed to another, but look at sharing those responsibilities either by partnering, either about collaborative approaches. And some of the examples of it's called collaborative or alliancing contracting. And examples of this includes the NEC contract. Go take a look at that. There's this framework alliancing contract called the FAC1 and the NEC contracts that all show you dispute resolution, how you can contract to work collectively. And if you have a contract like the standard form contracts that I have got this collaborative approach to contracting, then you're going to find that your parties at the end of the day are going to have far less disputes at the end of the day because they're working together. And the COVID-19 has explained to us that we are all in the same boat, right? We are not going to end up with disputes because parties want to have their issues resolved. They don't want to get into a dispute. They don't want to get into arbitration. They don't want to get into litigation. They want to have it resolved. So negotiations, mediations, conciliations are the best form of consensual dispute resolution. And for adjudicative dispute resolution, you have dispute boards. You've got a conflict avoidance board. You've got dispute avoidance and dispute adjudication boards. These are the approaches that you really have to consider for the future with India.
Sorry, sir, time is up.
Yeah, I'm done. Thank you very much for that.
Thank you so much, sir. Now the floor is open for audience and the session chair for posing questions to the paper presenter. Sir, you may ask the question. Ratan, sir.
Oh, sorry, I was muted. Mr. Changrot, can you tell us how construction industry in particular responded to the Law Minister of Singapore's appeal in terms of whether parties have given concessions to each other and how industry has responded?
Okay, so thank you very much for that question, Ratan. Very soon after the COVID-19 pandemic broke out, we had a COVID-19 Temporary Measures Act, and we were one of the first countries to have that in place, where we put in temporary measures where there is a moratorium for a fixed period of time where parties can't take their matters to disputes, where bankruptcy, if you're taking bankruptcy or insolvency position, the benchmark for taking bankruptcy actions or insolvency action is much higher than the norm is. And we've given an extension of time where parties can't call on their performance bond, parties can't take their matter to litigation or for a period of time that now in the construction industry is going to expire on the 30th of March. So that has actually been very, very helpful for the construction industry. There's also a method of assessing. So for example, I have a client who had a dispute. He put in a claim for his dispute to be assessed. So now he's going to go through an assessment which does not involve lawyers, and they will assess whether or not an extension of time should be given to be able to then deal with the problems at hand. So we were one of the first countries to have this in place, and it's been very effective. There are several other countries that have got the similar provisions in place as well.
Thank you very much, Mr. Changrod, for excellent presentation. I must say it was a very well done presentation. Thank you very much. Thank you very much.
Thank you, sir. So now we present the second participant, Miss Advocate Meera Kumari Singh with us. We welcome you, ma'am. Please, you may take over.
Good morning to all, one and all present over here. I am Advocate Dr. Meera Singh, and the topic on which I have written my paper is it's basically focusing on the construction industry. At what kind of dispute resolution mechanism we can opt in order to avoid the litigation. So how many minutes do I have? I mean, because I want to cover up all my points. So please kindly tell me how many minutes do I have to speak?
Ma'am, you have 7 minutes.
7 to 8.
Okay, 7 to 8 minutes. Okay, fine. Fair enough. As all my friends have covered the important point, yes, of course, it's very important for us to define the contract. If you're defining the contract, then only the parties, contracting parties, will avoid the dispute in advance. And in my paper, I have stressed a lot on the ADR and as well as an arbitration part. There's a reason behind why I have stressed on ADR and arbitration. That if as the way Mr. Ratan Soni has stated, that when you go for conciliation, negotiation, these are all great platform wherein you can really come to a compromising terms, because litigation is unending. It's not in India, it's throughout the world. If you lose in lower court, you go to higher court. Then in high court, if you lose, you go to Supreme Court. Thank God after Supreme Court, there's no further appeal. Otherwise, we'll keep on appealing. We have a problem. We all have an ego problem. So basically, as I'm from this industry and I'm working in this industry since 20 years, would like to state one thing is that it is the fault of both the parties in contract. It is not one. Too many papers I have just gone through, for this particular paper presentation. And if you see, they have always mentioned that it is the contractor who is at the fault. It's never like that. See, I am into this industry. It's a non-biased view which I'm presenting in front of you. Delayed payment is major cause, one of the major cause which happens. And how it happens, I'll tell you. Like Adani is into construction and they have subcontractors, and subcontractors also subcontract the things. So the loophole goes like that. The poor little man is not paid and it goes unpaid, and then there's a lot of things. Arnab's case, how he did the same thing. To the interior designer, he didn't pay. It's just an example I'm putting in front of you because everybody reads newspaper a lot. You being such a great media professional and still you are doing this kind of thing. So unethical thing always happens somewhere or the other. So it is not only the construction delay, a technical delay, but yes, of course, it is the delay of the payment which causes the major problem. However, it is a considerable point that if the other party is not paying, they are also under some obligation. But the work order is defined in such a manner that the payment should be done on time. Why? Because if one slab is completed, then already the contractor has already paid a huge amount for getting that particular span of construction. And still, if it is going delay, it will be too much of undue delay. So this is one of the causes which has not been mentioned in many of the papers which you will be checking on net or anywhere, Google and any platform. So this is one of the major causes. And the second thing which I want to stress upon is that, of course, ADR is a very good thing, but arbitration is better. Why? Because when both the parties will be incurring a huge heavy cost, it's something different from this. But let's take an example of Tata Industry. Ultimately, Supreme Court judges, they told them that please come at a consensus. Reason being is that both are grand. They both are correct. So it's very difficult, what even NCLT cannot do anything and Supreme Court also cannot do anything. So they said that please come in proper common terms so that you can go for a compromise. So similarly, if we keep on fighting and debating, we will not be getting anywhere, and litigation causes heavy losses. Of course, we lawyer get paid handsome and we enjoy, but for commoners, it's very difficult, and especially the contracting parties. Why? Because neither of the project moves and it's only the expenditure which they have to incur, and it causes, they are doomed, both the parties. So I believe arbitration is a costlier affair because they have to appoint their own judges. They have to bring them in the terms, and per day one judge sitting costs 10,000 rupees minimum. So even after doing this also, they further go to High Court and Supreme Court because they're never happy, as the way I told you in the beginning itself, that after Supreme Court also, if they will get a chance to appeal further, they'll go for further appeal. We people are never happy, and it is all the matter of ego. So the delayed payment thing, another thing is that they say that contractors, they don't do things effectively. Why? Because there is a BIS norm which construction industry people have to follow. But commoners, they think that by Googling, they will understand how exactly the project should move. So they do a lot of testing. I mean, in the mid, they will come, they will say that this cement is not good, that cement is good. So many quality checks and balances are there, but still they keep on watchdog poking noses. And that causes again a delay in the projects. But then ultimately they blame the parties who are actually constructing that you cause the delay. But if proper tracking will be there, then it can be easily seen that where the delay has happened and how the delay is caused. And apart from that, many companies, they hire a consultant on a consultant on a consultant, like the way Chanakya used to say that on a spy there should be a spy and on a spy there should be a spy. So it is an unending change. So somewhere or the other, both the contracting parties have to have a great faith on each other in order to make sure that yes, quality will never be compromised. At the same time, the time delay will not happen and the project will be delayed on time if there is no undue act done. I mean, there's no act done by God. Like this COVID-19, it's of course done by us, but it's ultimately he only did it. God only did it. So force majeure and all, many things are there which is applicable. So both the parties understand. So I would like to rest upon my whole idea of this conciliation and arbitration and many other things. The dispute will keep going on, but then we need to understand, contracting parties need to understand that we well in advance when we are drafting our contract, we have to make sure that which stream we will be going if there will be a dispute which will be arising. And rather than playing a blame game, we both the parties have to understand that exactly where the problem has happened. Because when there is a breach of trust or whenever there is no faith, then only the problems.
Last minute left.
Have a nice day. Any questions, please ask.
Thank you, ma'am.
Pleasure.
I now request Mr. Ratan Singh to please coordinate with, please ask the questions.
Dr. Singh, can you hear me?
Yes, I can hear you very well. Hello, how are you doing?
All good, all good.
Right.
I must appreciate your enthusiasm and passion for the subject. You talked about tracking of delay during construction phase.
Yeah.
Can you throw some light on how delay can be tracked during construction phase, if you can say a few words?
When we draft a contract, we always come up with a time span, you know what, wherein we write down, for example, like slab 1 will be completed within a month or so, or likewise, we have a proper timekeeper, okay? And when we start the construction, so whenever there is a delay, our project manager, he interacts with the customer. Now the delay can happen from both the ends, as we have discussed earlier also. That delay will happen like this, that maybe the client is not satisfied and he wants a change in the design, okay? So then and there the tracker has to happen. Now we have electronic mode and all the evidences are considered by Supreme Court of India when we are vouching it with 65B of Indian Evidence Act. So in that case, you can send WhatsApp messages apart from that email, and you have to mention that if this kind of delay is happening from the other end or from your end, so then how many days more will be increasing. So likewise, you can calculate the time cost delay, and then same thing can be presented. So if all these things will be available, so if people are going into dispute, so through ADR it can be solved, because immediately through that tracker you can find it out how the delay has been caused, when the delay has been caused, and who was the cause of the delay. So it will be immediately filtered out. So I hope I am clear with my answer. Is there any other question?
Okay, thank you.
Right. Have a nice day.
Thank you, ma'am.
Thank you very much. Thank all. Thanks for your patient listening. Thank you very much.
So now we have our third participant, Ms. Chandrika Tewatia Raj, along with co-partner Tija Goswami. You may take over, ma'am.
Yes. A very good morning to all the organizers. I hope I'm audible.
Yes, ma'am, you're audible.
Yes. Can you all see my presentation?
Not yet, ma'am.
Spotlight. Yes, we can see.
Okay. Yes, I'll begin. Thank you so much. So this is Chandrika Tewatia Raj from Navrashna University, presenting on behalf of me and my co-author, Assistant Professor Tija Goswami from Parallel University. The topic that we have chosen for today is the curious case of judicial intervention in arbitration in India, with special reference to construction contracts. So as Ms. Meera has already spoken about a little bit about construction contracts. So I'll actually, as I have limited time, so I'll actually focus more on the judicial intervention in these construction contracts. So let's begin. So as we all know, the slow and tedious courtroom processes have disenfranchised business from litigation. Therefore, more businesses or companies are entering into contractual relations having an arbitration clause to resolve disputes. So although Section 34 of the Arbitration Act limits the ground of intervention of courts, but in a clear dichotomy, we can also see Section 9 of the Act, which has allowed court intervention before, during, and even after the completion of the whole arbitration procedure, until even the enforcement of the award, which is under Section 34. So the problem which we can see in the Arbitration Act, which we will focus upon, is the provision of the public policy. So there we have Section 34, which is basically talks about that, which states that an appropriate court can set aside an arbitral award if and when there arises a question of its being in consonance with the public policy of India. So public policy is a concept which has not been defined under the Act. So we have given ample power to the judiciary to actually interpret public policy in various situations, which has created a tussle between arbitration and judiciary, and in favor. So we have related this to construction contracts. So let's go further. So as I have already told you, that although arbitration has gained grounds as a mean of an alternative to litigation for dispute resolution, yet public policy has been a subject that has always proved to be a hurdle in the enforcement of an arbitral award. So when we are talking about Section 34, we are speaking about an appropriate court in relation to an international arbitral award. Similarly, we also have Section 57, which specifically talks about a domestic award. So India, being the member of the New York Convention, which states that we have to implement, and the basic rationale behind it is the unilateral model laws, as well as the New York Convention states that we have to implement all the foreign arbitral awards in our own domestic legislation as well. Yet, because of the interference of the courts through Section 9, the non-enforcement of foreign arbitral award has become very, very common. So the ground of intervention, as I have already mentioned, has been given under Section 57, which has basically stated that if it is not in relation to the public policy or the law of our country, then we will term it to be ultra vires, and the award, which is the foreign arbitral award, will not be implemented. So the notice of arbitral award not given, or that being under legal incapacity, he was not properly represented. These are certain reasons according to which we can say, according to which the courts have said that you have not followed the procedure for arbitration which has been given in the law in our country, and that is why we will not implement this foreign arbitral award. So we have also found various case laws where specifically they have talked in relation to construction contracts, which have been where a foreign arbitral award has been given, but the same was not implemented in our country. So as you will see here, the case that we have referred to is the ONGC versus SAW pipes. So under ONGC versus SAW pipes, the Supreme Court deviated from the commonly practiced approach and stated that public policy must be attributed a wider definition for the purpose of enforcement of arbitral award. Thereby began the journey of India's tussle with the enforcement of foreign arbitral awards. So, but presently, after the ONGC versus SAW pipes case, the Supreme Court, due to the decision which had been given by the Supreme Court in this case, all the cases which went further after this were in this particular regard only. But now, as you will see, the absurdity of the broad interpretation of public policy led to shying off of international parties from adopting India as a venue as well as a seat of arbitration. So due to this case, we will see the ONGC versus SAW pipes. So many of the foreign arbitral awards, instead of implementing it in India, they started choosing another country as a seat of arbitration. But these days there is a new case which we came across, which is Sri Lal Mahato versus Progetto Grano Spa, where it was stated that under the under Part 1 of 1996 Act, which is the Arbitration Act, it would not be applicable to Part 2 of the Act. So what they've done is they've divided the Act, and they have said that Section 9, which is of Arbitration Act, where judicial intervention is allowed, will not be applicable to the Part 2 Act, where we are talking about foreign arbitral awards. So this is a new approach which the courts are trying to adopt, but which has not been fully adopted in our country. So now let's relate this to the construction industry. So we found a landmark case, which is Sangyong Engineering and Construction Limited versus National Highways Authorities of India. So in this particular case, we saw that even if it's a construction contract, in a construction contract, and this case was basically in relation to a foreign arbitral award. So in this case, the foreign arbitral award was implemented in our country, and even though there was a judicial intervention.
Ma'am, we have last minute left for the presentation.
Yes, thank you. I'll just wind it up. So so I'm actually going to focus upon this case. So here, it was, even though it was a foreign arbitral award, but in relation to construction industry, it was implemented in our country. So I think the construction contract, types of construction contract, and how exactly are these construction contracts, they are governed by the Indian Contract Act. I think this was covered by Dr. Meera as well. And why exactly are we choosing arbitration? So all these reasons, everyone, the reason that why we are choosing arbitration for construction contracts is that basically, even though we are not able to solve the issue, maybe we're not able to resolve the issue, but at least it will give us a refinement of the case. And as in the Sangyong case, the court did find public policy as a ground to set aside the arbitral award. And that is why we consider this to be a landmark case in consideration of arbitration to construction contracts. And in the end, I'll just conclude with...
Yes, time is up.
Yes, I'm just concluding. I'll conclude with a quote by Sandra Day O'Connor, who has said that the courts of this country should not be the places where resolution of dispute begins. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried. Thank you so much.
Thank you so much, ma'am. The floor is open for question. I request sir to please ask the questions.
Sir, you are on mute, sir.
Oh, sorry. You talked about dichotomy between Section 9 and Section 34 of the Act.
Yes.
Are you saying that Section 9 is not meant to support the arbitration? Is this your point?
No, sir. So actually what we are trying to say here is that Section 9 even has allowed court intervention before, during, and after the completion of the arbitral procedure, which should be a provision, which we are not denying that there should not be a provision like this. But we are also saying that because of this presence of Section 9 and because of the very nature of Section 9, where it has not been defined that what exactly should be public policy or what exactly, there are many fraud has been included, illegality of patent has been included. So these points which are there under this particular Section 9, where judicial intervention is allowed, have not been defined, and the definition which has been interpreted by courts is also very wide. So what we've suggested is that instead of directly interfering in these foreign arbitral awards, the limitation of the public policy should be more defined. That is what we have concluded, sir.
I'm afraid there is nothing like illegality or fraud which have anything to do with Section 9 proceeding. Anyways,
no, sir, not Section 9, sir. We are talking about Section 34 and Section 57 of the Arbitration Act.
Oh, my question was for Section 9. Okay. Anyways, thank you for your presentation. It was a nice presentation to hear. Thank you very much.
Thank you so much, sir.
Thank you so much, ma'am. So we have the other participant, Dr. MP Chengappa. We welcome you, sir. Please, you may take over.
Can you see my slides?
No, sir.
Yes, sir.
Yes.
Okay. Very good morning to one and all. Respected the chair and co-chair.
Let me defend it.
Shall I proceed?
Yes, yes.
Okay.
Yes, sir.
At the outset, let me thank and congratulate Adani Institute, and also I thank the organizer for giving me this opportunity to share my thoughts on this paper. The topic is on dispute redressal system in the light of the transformative legislation like RERA. Let me give some background as to this the dispute redressal system. As you all know that prior to the RERA, this area was highly unregulated. Ever since the independence, none of the lawmakers thought about bringing some the change with respect to dispute redressal. There used to be a couple of the reforms happened with respect to mining, mining area, or telecom area, or some other important areas, whereas dispute redressal with respect to RERA have not been taken place. There used to be purely ministerial and administrative remedies used to be available under different the laws with respect to getting the clearance for launching real estate projects, whereas the remedy for the purpose of getting justice, especially to the home buyers or the potential consumers, are very, very less. There used to be a lot of problems, especially with respect to massive delay in delivery of the possession, lack of transparency, accountability, standardization, professionalism in the real estate sector. And this is the people in India, they invest their life saving into real estate projects, thinking for better the result. But there are the cases we come across. There are huge empirical data also shows that how the industry, considered as a not proper in a professional standard. So many the fraud cases happened. The customer had to run to pillar to post, and the prior to RERA, the customer had to sign the agreement, and the agreement also had some sort of the arbitration clause where level playing field for the in favor of the buyers are not so strong, thereby buyers were remedy-less. The alternative remedies not effective and efficacious. Yesterday some panelist was mentioning about why RERA, why not the consumer dispute redressal body. Yes, consumer dispute redressal in the beginning, it was never intended to bring construction sector within the purview of consumer the act. It was only because of the Supreme Court pragmatic interpretation in Lucknow Development Authority brought the construction sector within the purview of the consumer, and consumer law is merely curative, not preventive in nature. And we have seen the very purpose of the setting of the consumer courts have been defeated because of the delay, and following cumbersome procedure, people have no ray of hope. Therefore, the Parliament of India came out with a specialized the body called RERA. In the year 2016, it was implemented. Rules were formulated in the in the year 2017, May 1st. Formally, RERA has been launched throughout India. The beauty of this law, it is a this law will be implemented at the state level. States have been given power to formulate rules and regulations. Now, the life of the RERA is only 3 years. We come across only few states have came out with a robust the RERA authority, and some of the states had to properly launch with properly launch. They are taking their own sweet time. Anyway, let me give little brief background of this the law. Primary purpose is to regulate the real estate sector, then protect the consumer interest, establishment of a specialized body called RERA authority. See, this law generally perceived to be one-sided. It is not like that. When you go through the entire provisions, this law also helps for the promotion of the transparency and objectivity. In a way, the developer also can get repose their faith in the system itself. Most important part, the dispute redressal system. As I said that this RERA is not in derogation of any other law. It is in addition to existing laws. Therefore, the remedies available under Consumer Act one can approach. Then, if the people want to knock the door of IBC, Insolvency and Bankruptcy Code, they can approach. Even if there is an unfair trade practice, one can approach Competitive Commission. One can file a FIR, lodge a FIR against the builder in police station. By invoking IPC, they can do so. So here, RERA being an adjudicatory authority, it has been given both administrative as well as judicial power. Administrative power starts from the date of registration of the RERA. And here RERA has set up adjudicatory officer in order to try and dispose the compensatory matters pertaining to section 12, 14, 18. Then the RERA has a conciliation form, especially when you look at Karnataka and the Maharashtra RERA. They have been following this conciliatory form. So many cases are being disposed outside the RERA. This is the good development. Then arbitrability of the dispute. The earlier presenter was speaking about public policy. Can RERA matters be arbitrable? This is one of the contentious issues we come across, because here is a RERA body, exclusive body set up by the state. Can matter be referred to the arbitration through agreement? That is okay. Let me take 30 seconds. So moving on to the conclusion, there is a need to strengthen the adjudicatory system in line of the Supreme Court decision, Gandhi versus Union of India or Madras Union Bar Association. Then there is a need to standard operation procedure for execution of the award. Otherwise, there is no the effectiveness of the decision of the RERA authority. Thank you.
Thank you so much, sir. The floor is open for questions. Mr. Ratan Singh, may I request you impose question?
Dr. Chengappa, very well presented. Issue this is really touches upon lots of people in India. Do you see any scope for the owner and contractor disputes also getting into the realm of RERA? One is flat buyer agreement or house agreement where you have promoter, developer and the buyer. But there is another stakeholder, which is the contractor who builds for the promoter and developer. Do you see any scope for having promoter or developer and contractor disputes getting somewhere in the realm of RERA?
So you are asking within the promoter and contractor?
Yes.
Yeah, within the promoter and contractor, I don't think that they will fall within the purview of RERA, the authority. Promoter as a whole, if you look at the definition, of the promoter. Promoter includes the contractor and the others also. Therefore, one the party will be the promoter and other party will be the home buyer. If there are disputes between them and they can resolve their dispute, they need not have to knock the door of the RERA.
Why I ask this question, that major disputes under RERA is delayed execution of the project. And the moment you talk about delayed execution, contractor is one of the important stakeholder. No, so I am seeking your suggestion. I am aware of RERA's provisions. What I was asking you is, can you suggest some way out, or do you have any position on this issue, whether the contractor, who is another stakeholder, can be part of this process? Obviously, for that you may have to have amendments and all, but would you suggest anything like this?
Yes, I think this is a very good idea, sir. I never thought of the problem. I think yes, RERA can have some sort of the wing within the RERA authority in order to look into the issues. I don't know at this stage RERA is having a capacity to look into each and everything. In days to come, they might. We can expand. If you look at here in West Bengal also, RERA just 6 months back it's kick-started. Some of the states, there is a need for capacity building program and states are not interested. So it takes another 4 to 5 years. There is a need for a lot of the change. The states have been given that power, rule making power. Nothing prevent state to come out with a rule. Especially RERA authority can recommend state government. That power have been given.
Thank you very much. Thank you very much
Yes,
for excellent
presentation.
Thank you, doctor.
Thank you, sir. So we have the other participant, Dr. Sujata S. Patil. We welcome you, ma'am. You may please take over. Ma'am, you are on mute. Ma'am, we will take your PPT later on. Now we announce the other participant, Mr. Harish Tiwari, with co-author Namit Srivastav. We welcome you, sir. Please, you may take over.
Thank you, ma'am. And I must thanks to the panel and chair and your institute for organizing the conference on such relevant issue and unique as well. So far, I have come across that topics like us, which we have presenting, I think unique in nature. And I would like to start with that the topic which I have chosen, that is dispute resolution in real estate sector, with the special reference to right to shelter of home buyers. So whether is ADR the way forward or not? So my paper is in the context looking at the aspect of the right to shelter with reference to these disputes, construction industry disputes. If we look at the investment is much needed for any developed economy. Investment in real estate sectors has grown rapidly during past 2 decades and has also contributed vastly in our socio-economic development of the country. And also it has uplifted the living standard of the society, since now people are having access to the homes by the virtue of such huge investment. But such investment often led towards the disputes. So disputes are bound to happen. It may be a regulatory disputes. It may be a disputes between the home buyers. Now, I have focused with reference to the home buyers and construction industries. And that dispute must have the resolutions. Traditionally, we have only the way that is litigation. People do come to the court of law for the resolutions. Majority of the stakeholders, I'm talking in reference of the home buyers, they don't know about the ADR mechanism, that whether it could be a way forward or not. In that context, if we look at that, they often jump to the court of law for the litigations. As we all know, that litigations always are costly affairs, not only in terms of cost, economic, but also in terms of time. And as we know, and we often advert the doctrine, Latin maxim, delay defeats justice. So delay in the resolutions always led towards the injustice. In turn, the right to shelter of the home buyers getting infringed. It has been encroached. It may be by the virtue of non-awareness about these alternate dispute resolution mechanism which we are talking about. But at the same time, when we are going for the realization of the right to shelter, in those cases, right to shelter of the home buyers is basically accessible when we are providing them justice in time. And also technicalities in making of the terms of the contract. The contracts have been made from the side of the real estate developers with the experts. But the consumers, home buyers, are not basically aware about those rights. And they are not much aware about the technicalities of those contracts and legal technicalities I am talking about. And they trap into those contracts. And therefore, that often led towards the dispute. And in terms, again, they are getting stuck into that litigations and they are not able to realize the right to shelter. And since right to shelter is the recommended and adverted by the UDHR, even the Article 21, and there are a number of international covenants that they are talking about, that having home and having decent home is the fundamental and basic rights. Many rights are basically founded on the having the right to shelter. If you have a home, you can have a privacy, you can have the freedom of speech and expression, educations. In that terms, it is required. So if we look at the demonstratial approach of the right to shelter in terms of these construction industries, it becomes a need of
Sir, we have last minute to go.
Okay, sir, I shall conclude. In that case, if we look at after the perusal of the pros of ADR mechanism in determining cases, particularly in real estate sector, we have enacted RERA and ADR, CPC section 89. There are a number of things. So I may conclude in saying that litigation, as we see that usual practice in case of construction industry dispute resolution due to non-awareness of the stakeholders. But looking at the pendency of the suit pertaining to the real estate developers and home buyers, we can say that by adopting new and innovative path to resolve the said cases is the need of the hour, and the DR mechanism has that potential that can be adequately solved and become a tool to impart the justice in time and time-bound manner, and therefore eventually home buyers can exercise their right to shelter in the true spirit, and that could be a good way for the same. Thank you, everyone. Now,
Thank you, sir.
having yes, please.
The floor is open for audience and the session chair for imposing questions. Ratan sir.
See, question for participants, if anyone was having. Basically, I tried to connect this particular home buyers with the right to shelter in my paper. Yes.
Yes, Mr. Tiwari, you talk about right to shelter. Now, the moment you talk about rights, right to shelter, basically your paper goes towards claim for fundamental rights, or basically it is indicating towards fundamental rights.
Yes, sir.
But your presentation essentially discussed about flat buyer, home buyer and developer issues. So, and that is again, that is not, that is a private law that comes within the private law realm. Obviously, for the dispute resolution, certain dispute resolution, you have RERA coming in the way. So how do you bring in this the aspect of right to shelter as understood under fundamental rights within this private law and contract situation? Can you throw some light on that?
Yes, sir. Basically, I'm trying to connect this right to shelter in my paper with context that if we are essentially and eventually, if the home buyers are not able to access, so this paper is basically addressing to the state and the existing legal mechanism and referring and adverting often to the right to shelter, that if we have that mechanism, those rules, so that it is an onus which has been imposed on the state that they can make those rules and protect the rights of the individuals and citizens as well. So in that context, basically, I have tried in this paper. Yes.
Okay. Thank you. Thank you. Thank you.
Thank you, sir.
Everyone.
So our next participant is Mr. Karan Kataria. We welcome you, sir.
Thank you. Thank you so much. Is my screen visible?
Yes, sir.
So good morning, one and all present here, respected chair. My presentation is on mapping the effectiveness of ADR, a review with respect to construction industry. So before starting my research, the basic research question that I wanted to answer to my research paper is arbitration successful in addressing disputes in construction industry? My research have been done by way of having a structured questionnaire. The questionnaire filled up from arbitrators, professionals, contractors, owners, and thereby making that quantitative data, interpreting the results and preparing a SWOT analysis for that particular research that I've studied, and I've got it from the various sources of not only questionnaire, but critically examining the present provisions with respect to arbitration, the previous legislation of 1996 and the present legislation in place. So construction industry, which was earlier only visualized as construction of houses and roads, is a vast industry added various range of attributes and activities to its shelf and includes various projects including but not limited to infrastructure, residential, commercial construction. In relation and interdependence of construction industry with other sectors can only be ascertained by contribution of activities by the construction industries to GDP, but it goes far beyond that. In India, the infrastructure sector has been a key driver of economic growth and have contributing significantly in Indian GDP, which have been around 8% with a little decline because of the slowdown or the COVID thing, but the signs of revival have been witnessing therewith. The construction industry is among the top 5 sectors attracting highest foreign direct investment as per the latest data. It also notable to write that Indian construction market is expected to be the 3rd largest construction market globally 2025. Now, with all the pool of advances, the benefits it's posing to our economy, it also carries a lot of inbuilt dispute in it. So the element of FDI, the element of the international players entering a market, we see Japan real estate companies coming up, the American triumphs, even where do I reside in the place of Gurgaon, there are so many foreign players that have entered market, and the complete NCR region, there every day a new project is coming up in respect of construction industries. Even in the road constructions and all, the foreign players are having a significant role. So that brings an internationality to this dispute, the dispute that arises, which is natural to any of the contract, the complex contract in the nature of construction industry. The problem of pendency is also there in dispute resolution mechanism with regard to pendency of dispute. Almost 60% of total claim against public sector undertaking and statutory bodies are still undecided. Almost 11% dispute are still undecided with statutory entities. The average dispute settlement time is determined almost up to 7 years. So the cause of dispute in the construction industry, I've outlined what could be the cause. So I've penned down various causes that my construction industry is suffering from. It could be starting from error and omission to defects in contractual documents, the failure of ascertaining the finance involvement project in initial stages, change condition, consumer reaction, people involved. Now, very important thing that I am on the ground reality is witnessing, the FAR, the increase in floor area ratio because of the Dwarka Expressway, the metro lines coming up, which was not there in their contract earlier. So the buyers are demanding the landowners with which the collaboration agreement is there of the builders. So they are increasing the number of the cover area, but the same benefit is not being passed to the landowners of that particular project. So the inbuilt various complexity with change of time, with change of new advances coming up in this specific area, the disputes come up. A study done by Kumaraswamy and Yogesh exhibited that the origin of conflict in the construction project are largely connected to subject matter of contract that may include extension of time, modification, issues relating to payment, quality of technical specification, information availability, administration, client's expectation, which are at times also unrealistic. This is SWOT analysis with respect to arbitration. Now, furthermore, if I talk about arbitration is where it is lacking. What I found is arbitration is somewhat becoming more formal with the coming times. The aim with which the arbitration was started, like it's somewhat being loosened up because becoming more formal, not just because of the proceedings that are taking place, but because of various other factors too. So I think that beside arbitration, the methodology of mediation should also take a center stage in dispute resolution, because at times the mediator could informally contact two disputing parties and he could come to a conclusion very sooner. Whereas in arbitration, the formal proceedings that have the formal structure of arbitration, which has converted itself in the present time, it somewhat is becoming a lacuna or a gray area in arbitration at present, which causes delay, which causes the lack of informality, which is required in the dispute resolution. So it is moving with a faster speed towards litigation. So mediation should be given a greater thrust in the construction sector industry.
Last minute to go.
Yeah, I'm just wrapping up. And the arbitration the element of informality which was there, the informal thing should regain itself. Thank you.
Thank you, sir. So the floor is open for questions to audience and Mr. Ratan Singh.
It was a nice presentation. Mr. Karan, you said that mediation is a better option. Yeah, we all know mediation is a better option because it is party driven and it gives you solution. It is cost effective and so on and so forth. No, but what if mediation doesn't work? So which of the two, litigation or arbitration, which of the two you will choose?
Sir, if mediation did not work, definitely in the complexity involved, the complex structure, the technicalities involved in construction dispute, we must and we should, I think, opt for the arbitration because it will incline parties toward a faster dispute resolution as compared to litigation. Because litigation, again, the complete more procedural form thing need to be followed up. The evidence is how it need to be laid down and everything, and I don't think the judicial officer who is presiding will at the very first place will understand those nuances, those technicalities related to the construction sector. So yes, arbitration with compared to litigation could be a better option for dispute resolution mechanism because it's in compared to litigation informal, speedier, less costly. So yes, obviously in case of litigation and arbitration, we first should prefer arbitration.
Would you agree for any suggestion to have specialized construction courts like you have in UK, the technology and construction court, or in various other jurisdictions? Would you advocate for a specialized court?
Surely, sir, we should have a specialized court for construction matters. The state government should look into this because the country and town planning department do look after various aspects of construction with respect to particular district or something. So if we have that thing particularly in place, yes, it will bear fruits and the dispute resolution mechanism will have a positive impact on this. Yes, we should have such.
Okay, thank you. Thank you very much. Thank you.
Thank you. We have our other participant, Miss Janu Share. We welcome you, ma'am. Ma'am, are you there?
If muted, take Sujata Patna.
Ma'am, so the other participant is Varshaning K. We welcome you, ma'am, and request you to present your paper presenter. Ma'am, are you there? Dr. Sujata S. Patil and co-author Ms. Shivani. We welcome you, ma'am.
Yes, I'm present. I would like to share my screen. It'll just take a minute. I hope it is visible.
Yes, ma'am.
Yeah, no, just a second. I have mailed the presentation. Could somebody share it on my behalf because I'm not getting the option here?
Ma'am, you have mailed to whom?
I've mailed it to Win.
Ma'am, it is visible.
Yeah, the presentation is another one. Just a second. Yeah, is it visible now?
Yes, ma'am.
Yeah, effective use of ADR is visible, right?
Yes.
Yeah, okay. I'm so sorry for the chaos, but yeah. Good morning to all the distinguished guests and all the organizers. So I'm Shabani Kinewadi from Navrachna University, and I'll be presenting on behalf of my faculty, Sujata Patil. So the topic that we have chosen for a paper presentation is effective use of alternate dispute resolution process in the construction industry. So to begin with, I would like to state that the construction sector in India has undergone significant development, and it is one of the key contributors to the progress of a nation. And also it highlights, it's the highest driver of economic growth worldwide. So in India, the infrastructure is among the top 10 largest sectors which attracts foreign direct investment. So along with the development, the infrastructure industry is also subjected to extreme complexities, be it in terms of contractual obligations, allocating of risk between the contractors and the owners, recognizing of rights of the parties in law, and equity as applicable. Hence, the number of disputes that are arising because of these uncertainties involved in construction projects and because of the magnitude of funds that are invested are certainly natural and are very prevalent. So these matters, some of them can be settled amicably if they are day-to-day matters, but some of them with a longer contract or the amount of magnitude of funds involved is larger. These might need to go for alternate dispute resolution as well. So in these kind of situations, the construction and legal laws become very helpful for resolving of the disputes. To go ahead with, let's have a look at what are the general causes of such disputes. It's usually the cause of a dispute usually lies in the contract. This often happens because of the contracts are not drafted in a consistent manner. They are not complete. They lack in accuracy, and all of these aspects and all of these incompleteness, inaccuracy, and inconsistency leaves a lot of aspects of the contract uncovered. Also, there are often tenders which are made hastily. There are faulty and ambiguous provisions in the contracts. The language is not really clear. Some parties might be comfortable with one language, some might not be. There is also deviation and unreasonable attitude of the contractor, which would lead to another cause of dispute. There can be unfair distribution of risk based on the contractor as well as the owner, which would lead to another cause of disputes. So to tackle the causes of such dispute, what we could do is we could go for dispute avoidance and dispute resolution. So even before beginning of a project, an appropriate strategy can be drafted for dispute resolution and dispute avoidance. So the client or the owner can take up the lead to draft a contract. Also, in such contracts, dispute resolution should be expressly mentioned in the contract so as to tackle the problem when it arises. Then in the contract, fair distribution of risk between the contractor and the owner has to be expressly specified. Also, special attention can be given to the dispute-prone clauses and identifying of neutral agencies to mediate such kind of disputes. Also, providing of binding mechanisms for ADR, which could also include constitution of the dispute review boards. Now, dispute review boards is a new concept which is used worldwide. This is at a prevalent stage when the contract begins, the construction contract begins. A dispute review board can be set up where where persons of the contractors and the owners are drawn and they meet up regularly or periodically to review any kind of pending or potential dispute that arises. So the setup of dispute review board can be another helpful mechanism for avoiding disputes and can be much more speedy process. So the mechanism of dispute resolution can be categorized into various aspects. It can either be through negotiation, through mediation, conciliation, also through arbitration, and there are many other area processes like the dispute review board I talked about. Also, a combination of mediation and arbitration, that is the hybrid, that is med-arb, is also a new thing that has come up, which is a binding determination, and it requires agreement of both the parties to go up with med-arb. So to start off with negotiation, it is an aspect where no neutral third party is involved. So the parties have to settle the dispute among themselves. So negotiation can be a very effective method at the early stages of contract, where early stages of problems have started arising between the contractor and the owner. Then mediation is a similar way of brokered negotiation, where there is a third party involved as a facilitator, but he necessarily does not make any decision. And conciliation can be synonymously used with mediation, which in some references, it involves a type of a shuttle diplomacy in which an independent third party listens to the disputes and then facilitates a settlement between those parties. And arbitration, as all of us know, it's a binding determination which requires both the agreement of the parties between both the parties, and if it's specifically given in the contract, then only you can go for arbitration. So as we have discussed, the causes which lead to arbitration are incorrect ground data, deviation, suspension of works, long-term contracts in the infrastructure industry, then no publicity involved, overpayment, levy of compensation of delays, delay in payment of bills are various causes which lead to arbitration in the construction industry. So what are the advantages of ADR over legal proceedings? Advantages of ADR over legal proceedings are the only way when it's very much time effective, as everybody has said, it's time effective, it's less costly, there is confidentiality of the parties are much more comfortable. And when it comes to arbitration, it is not a win or lose situation as it is in case of legal proceedings. You can settle the dispute.
Ma'am, we have last minute to go.
Yeah, sure, I'll conclude. So it can be a win-win situation in case of arbitration. So I guess that would be much more preferable. Also, to conclude with the topic, the industry must be very careful while entering into contracts, and to mention very clearly the contract itself, what is the mode that is going to be adopted for a systematic prevention and resolution of disputes, so that it could reduce conflict and litigation in the construction industry. Also, there can be a 3-step process that can be started, that is right from to prevent the problems from arising, staying right to prevent the problem from escalating into disagreements, and providing the resolution to prevent conflicts via the settlement of dispute review board at the first process. Also, ADR can involve different modes of resolving disputes depending on each and every case. The proper mode needs to be applied to resolve the dispute, so the matter won't reach to the litigation state. Also, dispute review boards facilitate the timely on-site of resolution of disputes. They emphasize early and continuing involvement of respected efforts. So this effort can be made to prevent disputes before even they arise. Even the amended Specific Relief Act 2018 is beneficial to the construction industry, particularly as it would cut down delays caused by lengthy court proceedings and reduce costs, which need to be focused. Also, project personals who remain directly involved in the disputes, that is right. Yes, just a second. Yeah. So these managers would play a major role as to resolving a dispute, because they are on-site managers, and it would be beneficial if they are involved in the dispute resolution process. So thank you. Yeah, I'm done.
Thank you, ma'am. So the floor is open for audience and session chair for posing questions to the paper presenter.
Thank you. It was a nice presentation, Dr. Sivani.
Yes,
you talked about dispute review board, or DAB yes. Now more called this, even FIDIC mentions yes. This as a DAB. There are good number of contracts in India which has got DAB provisions or DRB provisions.
Right.
But in practice, what we get to see is that invariably DRB provisions are not invoked. So you do not have DRB in place, and they straight away go for arbitration and whatever. So do you have any suggestion to improve DRB situation in India?
Right, sir. So what we could do is, sir, while the contracts have been drafted for the construction industry, like while in the initial stage before the contracts are being drafted, we could involve the dispute review board right in the contracts with the agreement of both the parties, settlement of a dispute review board, right in the beginning of the contract drafting process, so that it is beneficial to tackle the problem right in the first answer, rather than reaching at a stage where they would just like to go for arbitration. So installment of the dispute review boards in the beginning would be very helpful. So we could tackle it in that aspect, sir.
Okay. Thank you very much.
Thank you, ma'am.
Thank you.
I now request our respected session chair to kindly announce the honorable mention paper and best paper winner award. Now I kindly request Professor Gerald sir to take over.
May I?
Yes, sir.
Yes, sir.
Okay. So the best paper for this session was presented by Mr. Anil Changrot. He has got the highest mark, and I'll send you the marks later. And the second best paper, that is the honorable mention paper, is of the last presenter, that is Shivani and Varsin K. So from my side, it is Anil Changrot, the best presenter today. Thank you, Mr. Changrot. And second is Shivani and Varshina. That is the second one. Yeah, thank you very much.
Thank you, sir. Now I take this opportunity to thank guest of honor of this technical session 3. First, I would like to thank Philip L. Brunner, sir, for spending time with us and especially gracing this event from USA. I would like to thank Datuk Professor Sundra Raju, sir, for spending time with us for your valuable inputs in this conference. I especially would like to thank Ratan K. Singh, sir, for spending such a long time and chairing this session. Thank you so much, everyone. And we would like to begin our next session from 1:10 p.m. sharp. So I would like to request all of you to join by 1:10 p.m. Thank you.
And Ratan Singh sir, Lakshmi here. My special thanks to you. Special thanks to you. Without your support, this conference would not have been a success. Thank you so much for all your support, and you have been a support for a long period of time in my professional career. Thank you so much, sir. Thank you, sir. Thank you, sir.
Thank you.
Correct. I think முடிச்சாச்சு.